Paul, you weren't have help either. Okay. I think with Commissioner Gardner here, Commissioner Lee is unable to get through from his location, so we will go ahead and begin this meeting. We have Commissioner Sackridge and present, Commissioner Gardner on the phone line, and we'll go ahead and get started with that. I don't think I need to introduce anyone else, but thank you all for being here, and I appreciate that. The first two items on a regular agenda is approved Board Equalization Assessor approved review process report for September 28, 2028. Are there any comments on the content of that, Commissioner Gardner?
No, I don't have any, and I will move to approve that.
And I don't have any either. Was there anything that we should be aware of? Because I've gone through it and didn't see anything specifically that stood out. Okay. Then with that, all in favor say aye.
Aye.
Aye. That passes 2-0. Number 2, approved Board of Equalization hearing process report for report date of September 28, 2022. And any additional comments on that item?
I have none, and I will move to approve.
And I don't have any either, so all in favor say aye.
Aye.
Aye. That passes 2-0. Number 3, approve or deny the reinstatement of the primary residential exemption on the parcels listed in the attached spreadsheet for the tax year 2022. And I looked at it, and so we're going from secondary to primary residential requests. And they look like the others we've seen in the past. I don't see anything unusual about any of those.
I didn't either, so I'll make a motion to approve item number 3.
Okay, all in favor say aye.
Aye.
Aye, that passes 2-0. Number 4, approve or deny 2022 new property tax exemption application for Brigham Young University. Serial number, I'll ask the last few numbers, is 0067, 0001, and 0027. And
I'm wondering if we can take items number 4 and 5 together. I reviewed both when Sally sent them over. I feel comfortable with both, and I'm willing to move to approve both number 4 and 5, which are both property tax exemptions for Brigham Young University.
okay, for 4 and 5, all in favor say aye.
Can I interrupt your motion? Sorry.
One moment, council has a comment here.
I expected Vicky Westergaard may have had a comment or two on this. I don't know if she wanted to say anything.
Vicki, do you have anything you need to add?
Both of these applications were not sent in within 30 days of when the property was purchased. Bert, did you want to talk anymore on this?
Yeah, both the applications, the current statute requires that an application be filed within 30 days after the property is acquired by the tax-exempt organization. That law has been changed to be 120 days, but that doesn't go into effect until January 1 of 2023.
I think it's just 45.
What was that?
It's just 45. 45 days is the new rule in January.
I thought it was 120.
I reviewed it, but either
Okay.
way.
Anyways,
currently it's 30.
It doesn't change until next year. So current statute is 30. So realistically, the applications should probably be denied for 2022, but could easily be accepted for 2023. Although I know the assessor's office on item number 5, we would probably want to do something there in the body of the county commissioners, because we're talking about an exempt property going from a governmental exempt ownership to a 501c3 exempt ownership, which will require the assessor's office to assess a value and then exempt it. So for procedurally, I don't know if Jim wants to speak to that about that, but procedurally,
And that's number 5.
That's number 5.
And how far over 30
Well, and I
days?
was under the impression that the reason they didn't apply immediately was because they weren't using it for their purposes. Like they had acquired the property, but they were
Right.
not utilizing it for their mission property. So it would make sense to me that their application but they didn't file the application until they were using the property for a tax exempt purpose.
Yeah, the current statute, Commissioner, the current statute requires that they apply within 30 days of acquisition. And as part of the application process, that's when the county is able to determine whether or not they qualify. Basically, if they don't start using, if it's not put into exclusive use within the first 30 days, essentially they should be denied their exemption until if it's not put into exclusive use. That was the thing that got changed in the laws to give more time for the application to be made. But again, that change doesn't go in effect until 2023.
Out of curiosity, how much over 30 days?
So let me get this straight. So if a nonprofit entity purchases a property and they're not currently using it for a nonprofit purpose, and they don't apply within 30 days, and they can never in the life of their ownership of that property utilize it because they didn't apply in 30 days?
No, just in the first year, Commissioner.
The partial.
Okay, just in the first year.
Yeah, so that would only apply. So in other words, if they bought a property and don't apply and did put in exclusive use in the first 30 days, and then later put it into exclusive use later in the year, they are able to apply for that exemption the following year.
The other
Okay.
issue we
And
have,
I thought that's what they were doing here.
the other issue we have with number 5, the 207643 is a 2023 number. The two parent parcels were combined on a warranty deed in March. So the taxable parcels are the two parents, and 43 is the 2023 number.
Yeah, and that's why the official
And that's
action
why I
is not
thought
both
they were
parcels.
doing it for 2020. Yeah, that's why I thought they were doing it for 2023 because of that.
Right, but they applied for the exemption in 2022. I think someone from BYU here is here to talk about that.
So we had
Please identify yourself first, and
Paul Larson.
Paul Larson.
So the property was the Wasatch Elementary, I think that we're talking about, was purchased in a trade that took place, and but Wasatch Elementary is still using that property. And I think our understanding was that would stay exempt because it was exempt before. And then we realized that needed to, I guess, be exempt under Brigham Young University. And so that's when we sent in the application for that.
How far of a time after the 30 days, according to the state statute, did you actually apply?
How far after what?
After 30, how far past 30 days?
Did we apply?
Yes.
We applied in August.
Okay, so
Yeah.
That property was acquired in March, right? The Wasatch
I
property was March.
I think the trade took place at the end of March.
And then the apartment building was in the end of June.
Yeah.
That's what my notes indicate.
Yeah. Yeah, so those, that was the
Commissioner?
understanding there.
someone speak up. Is that Vicky?
Yes, I did have a couple questions on, I think it's the one that has the 3 parcels.
Yes.
I noticed that one of the parcels, the one ending in 01, it's the one where the Greek food truck is. And the other one next to it is the one where the shave ice place is. So I didn't know if that would have any complications with this application. Paul?
Yeah, there's, I talked to someone about that. Those were some food trucks that were on the premises, but I think you'd probably, if you went there today, those are, they're not both there. I think the shaved ice is gone and the other one could be gone too. They had leases that I think were through the end of September, and then they're vacating the premises. And if you go over there, you'll see that there's a lack of parking for the Riviera apartments, and so that's what it's being used for. You'll see a majority of that those parcels being used for parking for the students staying there.
The new rule goes into effect January 1, right? And 1347, does it apply in this?
That could be up to the board, up to the commission's discretion in a commission meeting. So it's on the table, I would say.
1347 allows us to adjust the rules and statutes to some degree, but it has to be denied here before that goes to the county commission. Correct?
Well, it doesn't let you adjust any rules, but it allows you to adjust tax amounts due.
Okay. So you got the property in March, and it wasn't actually applied until August, because you misunderstood the use of that property then.
Yeah.
Okay.
Well, that's just number 5.
Number 5.
Number 4 was probably a closer call. It was purchased in late June and then applied for in August. So missed the 30-day cutoff. I don't know by how many days, but
Late July.
We're probably talking
probably talking
days.
40 or 45 days or something like. I don't know when the application was filed. I can go try to find that, but
Yeah,
the
like
property was purchased. The date I have is the date provided by BYU was June 29th.
June 29.
yeah, and the application I think was done August 3rd or 4th.
Fourth.
August 4th.
Yeah.
So you're talking like 35 days or something.
So we are within 45 days. We're just
Yeah.
not within 30 days, right?
For the 2023 year, yes. But
Yeah.
2022, it's 30 days, so it's missed it by a couple.
If I may, Commissioners, just to set the record straight, it is 120 days in 2023. I just proved it. I just proved Paul wrong. I got to put that out there.
I submit.
I got to put that out there when I do that because it's so rare. But,
We'll have to have
but
council.
unfortunately, yeah, that
Do we
new
need to
deadline
change
is
council out for
2023.
another one?
Okay, so on this one, does that mean, like, well, can we approve number 4 and then number 5 can only be approved as of the 2023 tax year, or what are our options here?
It appears that the number 4 seems like we should be able to adjust that one now because it's so close of a window, but number 5 is a longer term, so we might have to deny it and to have it brought back to a county commission as an agenda item for them to invoke a different rule to change the amount of taxes due on it. Does that make sense? Have you done that before?
So
No.
Paul, how should the,
Yeah, basically,
Okay.
there's two different bodies here, same people. And so this board has certain limits on it, and it can do certain things, and then the county commission can do other options, if that makes sense.
so Paul, what are our options legally?
Well, technically, the code doesn't really give flexibility on the 30-day deadline. Commissioner Sakovic is recommending, it sounds like Commissioner Sakovic is talking about sort of encouraging a 1347 green folder process for tax relief for the remainder of 2022. I think everybody in the room agrees that these parcels would qualify for exemption in 2023. Did we get our questions answered on the vacant or the parking lots? It sounded like that was addressed. And so as long as, the board finds those, the second 2 parcels on number 4, as long as those are parking lots, I think that's,
That's doable then.
I think there's no question about 2023. The real question is how to treat these properties for the last few months of 2022. And like I said, technically they missed the 30-day deadline on both.
So in this meeting, could I make a motion that we approve items number 4 and 5 to become active in 2023, but not in 2022?
I think
Would that be an acceptable motion?
I think we have to, it sounds like the second two parcels, because they're parking lots, we should be able to allow that to go through. But the first parcel on number 4 and the only parcel on number 5, we may have to deny it here and have the county commissioner, county commission, then use the 1347 statute to abate all the tax that was accruing in 2022.
Well, the parking lot discussion is relevant because they appear to just be vacant, right? If you just looked at them on a map, they look vacant, and then they wouldn't qualify for exemption at all. But if they're being used as parking lots, then that would sort of tie them in to the larger parcel. And so you could treat them all the same, but it wouldn't allow you to approve them in 2022. If
That's where we'd have to deny it here, is what you're saying.
Yeah, so all 3 parcels
Right,
in number
so-
4 would be treated the same. However you treat them, they should probably be treated the same.
Okay. And that's the number 4.
Right, so if I make a motion to say we can approve tax exempt status for 2023, but we have to deny it for 2022, or do we just deny them because the application was late?
Let me just add something. So it says that they should be turned in within 30 days on the application, should be turned in. And I mean, to me, it was pretty vague on what it was trying to do. I was thinking, okay, it says it should be turned in within 30 days or by March 1st of the following year. Now,
All year be 2023.
yeah, I understand that now, that 2023 was for exemption in 2023, but that was not how I read that initially. I was thinking it was you could do either or, and but that I mean, you know, as soon as I realized what was going on here, I phoned down here to the county to talk to someone, and was trying to understand, you know, that process a little bit. And there was some confusion on when that 120 days would be in effect. My understanding is it was in effect, you know, last year or in 2022. And so getting that application sent in, you know, I felt like I submitted it by the due date. On the Wasatch, I mean, they were exempt previously. There wasn't a change in who was occupying the premises, but just a change in ownership because they wanted to get started on, you know, construction of the new elementary school. Right. So
and owners do bear the burden of the full scope of it. Is, you know, I haven't read that statute for a while. Is the word "should" in there?
No, that's a flavor of the application, but I'll own up to the miscommunication from the auditor's office on that. Mr. Larson and I talked about this, and when we talked, I thought the law would be in effect in May, which when the bill was run was the intention that it would go into effect this year, but that didn't make it into the legislation, and it goes into effect at the beginning of 2023. So I'll own up to the miscommunication on that. The should in the application is really just a wording in the application that probably could be clarified, but that's an application. That's just wording on the application. That obviously is not necessarily what the law accurately reflects. Okay. But I'm glad Mr. Larson brought that up because that's probably relevant to the discussion here because the school is the school still being occupied and used by the Provo School District or have they moved out now?
No, they're planning on being in it until the new building is constructed, maybe in 2024. So there is a lease between.
Okay.
There's a lease between BYU and the school district, but and that's part of the application.
So there's no question about the use, whether the use would meet the exclusive use exemption. It's clearly still being used for educational purposes, and BYU is BYU's new owner is also an exempt entity. We have granted that. The only technicality here we're dealing with is simply the age, is simply when the application was submitted. And as Paul stated, the application deadline for 2022 is 30 days. The 120 days does come into effect in 2023. I miscommunicated that with Mr. Larson when we talked on the phone earlier, because I was under the impression that it would go into effect in May, like laws have done in the past. So that's a problem. So there, it's up to the board
If we
to decide.
if we follow the language of should,
Well, the should is still just part of the application. That's not reflected in statute. So that's just a poor choice on the body
so
of
the
the
statute
form.
is contradicting the application. Or the application is contradicting the statute.
Maybe we need to change that to must.
Well, given that the current language is that, I'm inclined to go with the intent of the law and the application and just approve 4 and 5. Would that get me arrested?
I don't think you'll get arrested, Commissioner. We haven't arrested you on other things where we think you've been wrong. Just kidding.
But there's no guarantee.
No guarantee. I've got a couple witnesses here that did not hear it. There's no guarantee, so I'll bring them cakes later on to make sure that it stays that way. So I'm inclined just to go ahead and stick with the original motion and approve this. All in favor, say aye.
Aye.
Okay, that passes 2-0. Thank you. We'll need to fix that.
Great. Thank you
Thank
so
you very
much.
much, and thank you for your patience. Okay, number 6, approve or deny petition to Board of Equalization to hear appeal of property valuation after filing deadline for parcel, last 4 digits again, 0202. Owner record is listed as Funk, James Sterling, and Angela Jan Dolan. Anyone here to speak to this?
Sorry, excuse me, Commissioner, let me get to the right spot. This is,
Maybe as Bert looks that up, I'll just
Yeah.
make a quick comment. 6 through 12 are all petitions to appeal property after the filing deadline. So they would all have the same standard, which is they must fall into one of the specified grounds for allowing the late appeal. And just so we're all clear, valuation is not one of those grounds. And so they have to have either a medical emergency that would justify the late appeal, extraordinary and unanticipated circumstances, or a county error or a factual error. And so as we go through these, that's just since there were so many of them, I thought I would just let you know that there's the standard on these next 7.
Yeah, the first one was medical emergency.
yeah, if I can, I reviewed these applications. I put in comments on this one. The appellant statement is basically stating that they had a medical emergency with a newborn. Reading over their statement, it doesn't sound like that necessarily was a medical emergency, because medical emergency is more of a one-off situation, but this was a continuing situation with a newborn that needed additional medical attention after being born. I would say it's probably, if the board felt so inclined, either medical emergency or extraordinary or anticipated circumstances would be appropriate.
Probably both of those.
Yeah.
Okay. Would we have a motion, Commissioner Gardner?
Yeah, sorry, I'm trying to get to a place where I can hear a little better. Give me 1 second, guys. Oh, okay. I found a place where it's more quiet. So you said you're ready?
Yes, number 6, there was a medical emergency and extraordinary circumstances we're considering here. And it appears to be straightforward, and we're looking for a motion.
Then I'll make a motion to accept item number 6.
All in favor, say aye.
Aye.
Aye, that passes 2-0. So number 7.
Again, the appellant on number 7 is also claiming a medical emergency. My review of the application seems like this would be more of an extraordinary circumstance. A scheduled, rescheduled surgery is not really, I mean, I don't know if Paul has a different opinion, but in my reading, a surgery that's been scheduled or rescheduled wouldn't seem like an emergency, but more, again, just an extraordinary circumstance that could affect the appellant's ability to file by the September 15th deadline.
And I'm reading the back and forth she's had to do for this support that she's giving.
Yeah.
I'm inclined to do the same thing. Commissioner Gardner?
Yeah, me as well. So I'll make a motion to approve item number 7.
Okay. That would be number 7. All in favor, say aye.
Aye.
Aye. That passes 2-0. Number 8, approve or deny for property 0046. Appeal number 1303, 2022.
On this one, the owner is basically stating that they did not receive their notice because it went to a P.O. box. I checked the warranty deed. Now, this is their first year owning the property on the warranty deed, which is the only deed recorded. There's no additional documents recorded. It only lists the P.O. box as the address to mail the notices to. So essentially, the notice went to the address of record, to the owner of record. The owner obviously got the notice. They just failed to open it and pay attention to it before the filing deadline. Our office doesn't see anything here that rises to an extraordinary or unanticipated circumstance. And they haven't listed any kind of factual issue that in which the board could accept the appeal. Their basis is just simply valuation.
Okay,
Do we have anyone here to speak on their behalf? Did they come to this meeting?
No, Commissioner. For these, we only bring the petitions to the board. The appellants are not invited to come. That's been our process.
Okay, so that's all the information we have then?
Yes, unfortunately.
All right, then I'll make a motion to deny item number 8.
all in favor, say aye.
Aye.
Aye, that passes 2-0, is denied. Number 9, approve or deny property owner, or property number 0020, appeal number 1304, 2022. Extraordinary circumstances, missed the deadline.
In this, the appellant stated in their petition that they misread the valuation number, but it looks like the appeal notice was received timely and opened timely, but they just misread the amount. They thought the amount was, I believe, 604, and the amount was actually 804, and only decided to file an appeal after it was pointed out to them that the amount was 804.
And what kind of home is this? Oh, it's a Rambler, I'm sorry.
Yeah, it's a single family.
And this is located where? Up in Highland. That's a major jump.
I don't know what to do with that. So, I mean, was the appeal filed, it was not filed on time?
It was not filed on time, Commissioner. It was filed after the deadline, and the appellant is essentially saying, I misread my valuation notice, and that's why I didn't file on time.
I'm probably going to have to deny that one. I will make a motion to deny item number 9.
And with this denial, what happens again?
If having it denied here, the appellant is given the ability to appeal the board's decision to the State Tax Commission on the basis of that we denied their late petition inappropriately. Or they can make a case to the tax commission. Anyways, they can make their case to the tax commission also.
Yeah, okay. I have to go with that as well. So it'll be spelled out in the denial that they can go to state. Okay, all in favor for the denial?
Aye.
Aye, passes 2-0. Yeah, she's right. 24% increase in taxes on a 26-year-old house. Gotta love it. Okay, number 10, approve or deny parcel 002, appeal number 1308, 2022.
In this petition, the appellant unfortunately did not provide any reasoning as to why they weren't able to make the filing deadline. They stated that the appeal is a factual error, but they also didn't provide any evidence as to what errors existed. So essentially, they didn't. I hate to say it this way, but they didn't essentially bother. They didn't bother to read what they needed to do, and they provide us nothing to make a decision on.
Okay.
I might just
All
add
right,
that,
I'll make a motion to, oh, yeah.
well, just for, when an appellant claims factual error, the assessor's office needs to provide their approval as well. So the board needs the assessor's office to join in on the factual error type.
Oh, thanks for pointing that out. then,
I looked
please.
this over, and since they didn't specify what the factual error was, there's really nothing to respond to.
Okay.
That was Jim Stevens from the assessor's office, for the record.
Okay. Commissioner Gardner,
I'll make a motion to deny item number 10.
all in favor, say aye.
Aye.
Aye, that passes 2-0. Number 11, approve or deny 0063, appeal number 1309, 2022.
My review of this petition, they are stating a medical emergency, or I can't remember if it was medical emergency or extenuating circumstances, but
Extraordinary anticipated.
yeah, or the fact that the COVID went through the family. I have a hard time with these was because, COVID symptoms can range from a mild cold to hospitalization. They didn't give us anything more than, oh, hey, we got COVID. Typically, if you have a cold, I don't know how that would necessarily stop you from filing something on time if that's that important to you. But again, we know the COVID symptoms can really range from, nothing, you're just fine to, put you down for several days. So,
Or in hospitalation. but
Right,
yeah. And
exactly.
It's kind of open-ended in his description, but
yeah.
I'm inclined to go with this one.
Okay.
Commissioner Gardner,
Wait. Yeah, you cut out a little bit. What are you inclined to do on that one?
I'm inclined to approve this one because of the COVID. It doesn't go in much detail, but I got it, and I slept a couple weeks away.
Okay, then I will make a motion to deny item number 11.
I was going to approve item number 11.
Oh, you were going to approve? All right, I'll make a motion to approve item number 11. I will modify my motion to be the exact opposite.
Okay,
to
good.
approve
That
item
way it
number
won't be hanging in limbo. So get my way on this one. How's that? So all in favor
That's
to
great.
approve number 11?
Aye.
Aye, passes 2-0. Number 12, approve or deny parcel numbers 0001, appeal number 1311, 2022.
So this one, they're stating is factual error. They give a reason for missing the filing deadline. However, they did provide information as to what the error was. And so if the assessor's office agrees that an error exists, we don't necessarily have to accept a compelling reason. So I would see if the assessor's office agrees there is an error that exists.
Yeah, it says they're being taxed on the wrong acreage.
Clarissa Reeve with the Utah County Assessor's Office. They recorded a document they started recording documents in August and then into September of 2022. So as of January 1st, there was no factual error. This is an existing parcel. Mailing address didn't change. So we were mailing to the same address that we have years past. Acreage didn't change for 2022. I don't see any cause for a factual error.
Okay.
What about the extenuating circumstance? They kind of claimed both. Did they list reasons for an extenuating circumstance?
Let me pull up the application real quick so I do a quick review. I didn't really look at the reasoning because there was enough to say for a factual error to be considered. But they say that the notice was sent to the wrong address. I did look at the notice history on this one. We've sent it to the same address and the same ownership for several years. I can only guess that if it went to a wrong address, it meant that perhaps a mail carrier error delivered it to a neighbor, and the neighbor took their sweet time getting it to the owner.
Which is possible.
Yeah.
But and what he's saying here is that about 0.032 acres was given to the property north, which is vacant field. So he's claiming a piece of that off?
Well, essentially, that's what Clarissa from the assessor's office is saying, but that was recorded after the January 1 lien date. So in terms of that will go in effect for that'll go into effect on the assessment in 2023. It did not necessarily affect the assessment for 2022 because we're only snapshotting once a year.
Got it. So you'll just have to spell out to them when we deny it,
Yeah,
if we deny it, yeah.
yeah.
Commissioner Gardner?
Yeah, if we don't have, any evidence of that, I mean, other than just them saying they didn't get it, that's, difficult for me. What are your thoughts, Commissioner Sakovic?
I'm inclined to deny this one, so.
Okay, I will make a motion to deny item number, where are we on 12?
Number 12.
Yeah, a motion to deny item number 12.
Okay, passes 2-0. Thank you. And then we have the last item, 13. This is approve or deny status for Stuart David Bagley, living in irrevocable trust, serial number 0017, continue from August 25th meeting.
Okay, Mary Ann Hansen appearing. I'm Stuart Bagley's attorney. I was here last month and then it was continued. And Commissioner Sakovic, you weren't here, so I don't know exactly
I scored big time. I got COVID. I apologize.
whether you want
I
me
was the one who was
to
complaining who was asleep for nearly 2 weeks.
go over stuff. Since our meeting last time, my client has talked to a member of the USDA here in Provo. And this is kind of a general letter.
I can no longer hear what's going on. You have to speak into the mic.
I can just briefly go over. He was limited in exactly what he felt comfortable doing for obvious reasons, but he's verifying that my client has been part of the farm program since 2012 with the USDA. They go into the office every year. My client reports the number of colonies, bees, honey production, losses, increases. And then he also talks about how important beekeepers are. And he indicates that in the state of Utah, it's where this state is the second largest producer of tart cherries in the U.S., and we're only behind Michigan. And that in Utah County produces 95% of these tart cherries. So he's just talking about how vital bees are to agriculture, and that they're essential for pollination in the orchards around here, and that the beekeepers also contract with people outside of the state of Utah. And I know that you guys are aware of this, but we thought it was important for you to know. I don't know how to put this without appearing to be rude, but my level of frustration is really high here. When we were here last time, and have you had a chance to look at this, Commissioner Sakovic?
Yes.
Okay, because I have extra copies if people want them. These are standards of practice. They were adopted by the Utah State Tax Commission. It has a 7 on it, so I'm assuming maybe this is the 7th version. I don't know. But they were revised August 30th, 2021. So almost exactly 13 months ago, the state came up with these standards of practices. And so when we show up and we thought we had a really darn good argument that my client qualified under these standards, then we get the State Tax Commission, and I don't know if you've had a chance to look at the letter from Brady Kelsey.
I have not.
I have an extra copy here. I have 2 extra copies. And this is what was really frustrating to me. Up in like just a few lines down from the top, he's saying the language in Standard 7 is much more vague than we would like to have. They're their standards. They adopted them. Based upon the standards, my client relied upon the standards that he could have a storing or apiary, and now they're saying they're vague and they don't like them, but they're their standards, and they didn't like the fact that my client was applying for the to be in the green belt. But then he talked to one of the members, and he's saying they stock anywhere from 1,200 to 2,000 colonies. My client's been in the bee industry his entire life. His family's been doing beekeeping for 130 years. And he's not aware of anybody down there because it's kind of a small community. He says that they usually don't stack them that deep. And Commissioner Sakovic, you weren't here last time, but we had Mr. Bagley's dad here, Dan Bagley, and he talked for quite a while. He's been doing beekeeping for 70 years. He knows what he's talking about. And they have always, their practice throughout the 130 years is not to put that many colonies together. And they do that because it's real easy for them to get diseases. It's just like COVID. That they don't like putting that many colonies on one property. So if one gets sick, they all get sick. And then there's also the issue of fighting, that they destroy each other when they start fighting certain bees. And so they have never stored all of their colonies in one location. And so we take offense at that. And then down at the bottom, they talk about they don't want to open the floodgates to allow beekeeping as a sole activity to qualify large parcels of land that don't fall within the intent of the FAA. I think that Mr. Bagley clearly falls within the intent of the FAA standards of practice. In that, it clearly says the purpose. They adopted these standards, and the purpose is to promote equitable administration throughout the state of Utah. And so they're the ones that came up with these rules of standards of practice, and they made very specific exceptions for beekeepings. They require a reasonable expectation of profit, and we already went through that before. And I know Commissioner Gardner was adamant that, yeah, it was clear my client was doing this with a reasonable expectation of profit. He has licenses.
And you essentially got somewhere between 40 to 100,000 bees.
Yeah.
And
So I sat down and I talked with a lawyer afterwards, and I think that our assessor's office was interpreting the standards and codes as an and it really was an or. So, for example, what they were, in my opinion, what they were judging your client off of is I feel that the assessor's office was judging your client off of all of the recommended use of the applicable uses. And I think that was an incorrect interpretation of the law for them. I think it should have been an or, and I think your client absolutely meant the or. So I'm 100% ready to vote yes and to approve your application because I feel that the assessor's office misinterpreted the law by putting an and where there should have been an or.
Okay, well, then I won't argue anymore.
Can we have a commissioner, or excuse me, the assessors come up and comment? Ben?
This is Ben Stanley with the
Yeah, we
County
talked
Attorney's
about this
Office.
extensively.
Yeah, this is something that we've discussed at length last month. You weren't here, Commissioner Sakovic, but this item was continued. We looked at standard of practice number 7.5.1, which deals with apiaries and beekeeping specifically. And that particular provision talks about not ands or ors. It talks about some evidence of reasonable expectation of profit for a honeybee operation could include and lists a number of kinds of evidence that would be valuable. We don't dispute that honeybees are incredibly valuable to agriculture. We don't dispute that this
Right,
particular
but what you're
taxpayer.
disputing is you're saying
Commissioner Gard,
things that it may
Commissioner Gard, let him
include, and
finish.
you guys went through all of them.
Let him finish.
Okay, well, you know what? I should not be in this meeting. Commissioner Lee should be in this meeting. I'm currently walking down a street trying to go do this. I've already talked about all this, so I'm going to put myself on mute. When you're ready for a motion, let me know.
Okay. For the benefit of you, Commissioner Sakovic, we had this discussion of section 7.5.1, which deals with the standards of practice of the Tax Commission over what apiaries should allow, whether or not bees should qualify parcels of land, large tracts of land, for Farmland Assessment Act assessment and greenbelt status. Generally speaking, the Tax Commission does not treat beekeeping as the primary basis to justify greenbelt status. It's a tertiary or a secondary at most, and there's grazing that happens that is the primary justification because it's a difficult one to measure. The standards aren't very clear. They say things like beehives being placed on a parcel of land would not typically qualify land for FAA assessment. But they also say it could under certain circumstances, and they list a number of kinds of evidence that would be valuable. What the training that has been received by our farmland assessment analyst here in Utah County speaks to is the need to have pollinated plants on the property, to have specific standards. One of the concerns is that in this particular case, we have 50 hives that are trying to justify 5 acres of land. And so in the meeting last month, on Commissioner Lee's motion, the matter was continued for this month so that he could gather more information, and he asked us to look into things. We got a letter from the State Tax Commission auditor that was referenced by the council for the taxpayer here, and I'll just read a couple of excerpts from that because I think they're valuable and helpful. This is, again, is Brady Kelsey. He says things like, and he speaks to these questions of the death rate due to fighting and how much density is really appropriate. He says that in discussing with member of the consortium of beekeepers in southern Utah that they stack anywhere from 1,200 to 2,000 colonies at one location to winter their bees each year. They say the death rates are between 1% and 5%. They give a number of statistics, but he basically says that it's 4 times more generous than that to give the 50 acres or the 50 hives a qualification of 1 acre of land. And so his recommendation is that this number of beehives, if it was the sole source of qualification, would only qualify 1 of the 5 acres. You've got to qualify all 5 together if you're going to qualify them. The phrase that he uses that I think is very compelling here is he says, looking back at historical, well, here's the one. It is our belief that 50 colonies spread across 6 acres would be greatly underutilizing the acreage for the purposes of the FAA program. Again, this is the auditor from the Tax Commission. We understand certainly the taxpayer's frustration. We appreciate that the standards that have published, and as Mr. Kelsey acknowledges, the standards that they have published are not ideal. They are continually refining them. There have not been a lot of applications that deal with beekeeping across the state as the sole basis to qualify land for FAA assessment. But the question before you is this a sufficient utilization of this land to have just 50 hives just wintered for a brief period of time where there's not pollinated flowers on the land, where there's not grazing any longer on this particular parcel? Does that really qualify it? And do you open floodgates? If you make it too easy and you have standards that deviate from the recommendations of the State Tax Commission's auditor, if you adopt different standards, you ought to think about whether those standards create too easy of an opportunity for people to rotate a few hives onto their property for a few days to get qualified for greenbelt status. You've got to be fair to all the taxpayers. That is the reason why the assessor's office declined this application initially. We're happy to answer questions about it, but we want the Tax Commission, we want the Board of Equalization to understand what the thinking was, the rationale, and to see this letter that came from the Tax Commission's auditor, which was in response to the request for additional information. That is the assessor's position, is that this property shouldn't qualify. The standards are that this is an underutilization. It's not sufficient bees for a sufficient amount of time to really be a primary source of justifying why this property should get greenbelt status on all 6 acres for the year. But again, we're happy to answer any questions.
Now,
I specifically asked in the last meeting, how many hives do they have on it? Right now, they said 50, but I said, how many have you had? And they said it varies from several hundred to 50. And so it sometimes goes up and sometimes goes down. And so that's why I feel comfortable with this, is just because they happen to have 50 right now. It's kind of like sometimes in a drought year, you don't have as many crops growing on your land. And so for us to figure the AMUs off of their drought year and take away their greenbelt status based on their drought year, when they said in the past they've had several hundred, well, if the tax commission is saying that 50 accounts for 1 acre, well then my math tells me that 300 would account for 6 acres. So when they say that in the past they've had several hundred, that's why I'm having a problem with this, because when we specifically asked, I said, how many have you had on that property? And they said it varies, and it goes from several hundred down to 50. They have to be below right now. So is that correct, or is that Incorrect.
And from our perspective, we can't grant greenbelt status on the basis of undocumented guesses at what it has been at some unspecified time in history. The evidence we have in the record is a brief period of wintering on this parcel of 50 hives. That was the year in question that the analysis and the appraisal was done under, and that's insufficient in the view of the assessor's office, and we submit it's insufficient in the view of the auditor for the State Tax Commission.
Would there be a comparison to land, say, used for growing corn or hay, rotated, and then cattle? Is this similar to that, where some seasons there is scarce produce production rates as opposed to other years?
Well, and
When
again,
we say several hundred colonies down to 50 colonies?
yeah, and from our perspective, certainly with cattle and corn and specific crops, the standards that are published, the tables that come out of the Utah State University deal with the amount that's required in production and what 50% of that would be. It's a lot easier to quantify. It's a lot easier to specify. I think we all agree that there are deficiencies in the standards of practice when it deals with apiary specifically. The Tax Commission is committed to get more refined and more effective standards of practice to help us with better details. But what we have been told is that 50 hives would be sufficient to qualify a single acre, not 5 or 6 acres. And so yeah, I think you do consider, certainly in the context of the Greenbelt and the Farmland Assessment Act, when you're dealing with things like agriculture and crop production, there are opportunities to point out that there were factors outside of your control that caused a shortened. In fact, we've seen applications where fires destroyed crops and things like that. But the requirement of the law is that they be doing everything they can to meet the AUM production, which again is not well specified with bees, but we do have this letter from the Tax Commission suggesting what their thinking is.
Well, the other question that I have is, you keep using the terms beekeeping and apiary interchangeably, but I don't believe that they are. There's one thing to be a beekeeper who's making honey, and that you are a beekeeper for the purpose of making honey. There's another thing to be an apiary that's for the purpose of pollination, and those are not the same things. And so then my question is, was there AUMs based on apiaries, or was there AUM based on beekeeping?
The letter says data on apiary density is not nearly as standardized as the carrying capacity of land for grazing type animals. I don't know if you've had a chance to see this particular letter. It was submitted to the taxpayer and to the board a few days after the hearing in August, when this matter was continued to the September meeting. But he talks about it primarily in terms of apiary density. I don't know that certainly the standards of practice as they exist, 7.5.1, do talk about forage and other elements that are necessary for the making of honey. And they say forage cultivation, if forage blooms are cultivated on site, the seed mix provides for quality, marketable honey with an overall bloom that is sustained throughout most of the year. A well-managed acre can provide enough forage for up to 100 hives. However, the 50% production requirement would be met by supporting 25 to 50 hives per acre. So I think that they see the standard as somewhat interchangeable. It's 50 hives will qualify an acre.
Well, sort of, except for if you're doing it for honey production as opposed to pollination, right? So they said apiary, but then they were talking about honey production, which, as far as I understand it, honey production is a side benefit of this operation. Their primary operation is raising bees for pollinators. I just think it's too complicated. I think the State Tax Commission to handle it. Their guidelines are not, they're very loose. They're not defined. It's not as easy as us saying you use the AUMs or you don't. I'm inclined to approve it because I don't feel like we have sufficient guidelines. And I feel that they're utilizing, that I feel like they're using the terms interchangeably based on whether or not you're doing this for honey production or pollination. I haven't seen really good, solid evidence from them. I've seen us using terms interchangeably between pollen production and honey production. It's not a call I feel comfortable making. And I do know that last week, when there was like a list of 7 things, like they checked off the majority of them, but it wasn't all of them. And I feel like, honestly, last meeting, and I feel like this area is not sufficiently defined enough for me to be able to deny this.
It would help me if the Mr. What's his name? Reese of the USDA could give some. He says that the Bagley farm has been doing this since 2012, so the last 10 years, correct?
Well, I guess I've been meeting with him. The family has been doing beekeeping for 130 years. Maybe Stuart and my client, Stuart Bagley, can clarify that.
Hi, I'm Stuart Bagley, the beekeeper and the property owner. We have just been doing business with USDA in the last, my dad started in 03, I started in 2012. We have not really needed the USDA until big collapses, colony collapse, things like that, where we needed to get loans and get crop insurance to help us keep our business going.
Okay.
And another thing on the property, we also use it for winter storage, which is very specific. And a staging ground, just like a cattleman would use it, is a stockyard for staging before they take their livestock to up into the mountains or elsewhere.
This would be more helpful if you had a little bit more specific on the ebb and flow of numbers of colonies.
He's got the information. We can go back as far as you want since we started with him, if you want that information. And it'd show you the fluctuation from
What I'm thinking
800 plus colonies
because
down
we
to-
have
we're
two different
struggling now.
opinions here.
Yeah.
It makes it tough.
And we're at a disadvantage because he was reluctant to really, if he was going to talk with me, he would say something different than what he would be willing to write in his letter. But
What he
it's the
writes
state-
is crucial in all of this.
Yeah, well, it's the state. They adopted the standards of practice. They specifically say, for example, an apiary or bee yard used in the staging or wintering a large number of beehives may fully utilize 5 acres. They're the ones that adopted these. They're fairly new standards of practice. My client relied upon that, and now he's being penalized or attempted to be penalized.
Could you get Mr. Reese to comment and tie that into the standards of number 7 there?
Can I?
Yes.
Right now?
No, not right now.
Oh.
Well,
The problem is my client's paying me a lot of money. We were here last time.
I know.
We're here today. Like now we're getting into, is it even cost effective for him to have me here fighting? He's doing it for the beekeepers out there.
Right.
But we were here before.
But we got two opposing views here with Commissioner Lee and Commissioner Gardner.
Well, not Commissioner Lee, I don't know, and maybe Commissioner Gardner. can
Commissioner
chime
Lee
in.
was ready to vote with it as well. Commissioner Lee did not disagree with
He wasn't
on this. He
disagreeable.
continued it because he wanted more information, but Commissioner Lee, and the reason he wanted more information is because he understood what we were saying. So there's not an opposing view out of Commissioner Lee.
Let me see.
But it's the state tax commission. In their own documents, they say it's vague. They don't want to open the floodgates. However, there has to be a reasonable expectation of profit. My client and all their things, as Commissioner Gardner stated, all those boxes have been checked off. This isn't somebody with 2 hives trying to sneak in. And,
No, I get that, and like cattle, like
Yeah.
raising corn, there's never a flow depending on the seasons. But what I'm struck by is that he says it's absolutely crucial, but he says if he got more than 1 acre, that's too much. So that's the constraint I'm following. You've been at this for 110 years.
Yeah, but I think if more than 1 acre is too much if they're primarily raising them for honey. But it's not taking into account their winter operations. They winter them there.
and they
Yeah,
rotate them.
I felt from what I went back and rewatched the meeting last time, went back and reread the statute, and I feel that as an apiary, they may not qualify as a honey building the operation, but I feel as an apiary who winters there and who utilizes this operation to transfer hives, and their entire operation has well more than 50 hives. That just happened to be how many they wintered there. Under that scenario, I felt comfortable moving forward and granting the appeal.
Okay. Mr. Stanley, could I ask you a question?
Of course.
I think there's a relationship between types of cattle, which is one, and crop raising. And there's an ebb and flow on both. And we've gone through several of those over the past little while that I've been here. Do you see a relationship between these?
I'm not sure I understand the question
In
exactly.
other words, some seasons you have a large crop, and other seasons you got droughts, and so you do not produce what you normally would produce. And it could be a couple of years in standing. We've had to go through those in the past.
Yeah, it's undoubtedly true that you're going to have fluctuations and variations in your production. That's why the statutory framework and why the State Tax Commission and the legislature have required only 50% of the average production as tabulated and promulgated by the Utah State University tables about agricultural production. So they'll say you can get these many cattle for this many AUMs, animal units per month, on your property. That's what you're expected to do on this kind of land, and you're only going to be required to have half of that. What they're telling us here in the letter from Brady Kelsey is that they see, for apiary purposes, this density sufficient to qualify 1 acre. And so that's their perspective. That's the State Tax Commission's auditor saying that's what we would say that this would qualify. What they're looking for is to make sure that they are fair to all taxpayers, that we're not making it too easy to qualify some particular use over others, that make it artificially incentivized to do beekeeping in hives for the winter months on your property and not worry about real active devotion. What the law requires is an active devotion to agriculture production, a reasonable expectation of profit, and a sufficient number of acres.
And that's why I'm constrained, because this one doesn't talk about numbers of, it just talk about the industry. And this one says, even if you had 50 colonies, you only need 1 acre.
Yeah, you
which I
only
see that.
qualify
But
1 acre.
if he says that actually it could be several hundred colonies, that maybe 2-3 acres or more, and that's the thing I'm left with. I don't have an answer for.
Well, and my suggestion there, Commissioner, is both parties have appeal rights. We've had recommendations this be continued. We hadn't seen this letter until today, whereas we provided our letters more than weeks in advance. But ultimately, it could be continued for more information, or you could just make a decision and know that the two parties both have their appeal rights. Ultimately, what we're interested in the assessor's office is making sure that we do not open floodgates and make it too easy to qualify some things in a use that doesn't actually fully and meaningfully utilize the property that's seeking this special exemption and tax treatment. The Utah State Supreme Court and the Utah Constitution require strict interpretation of the law when it comes to preferential tax treatment, because it shifts tax burdens away from some people to other people. And so we don't have anything at all personal against any taxpayer. We want to help them all.
Do we have, as
we wanna be
assessor,
fair.
ever recorded anything more than 50 colonies? Have we ever seen that?
It's not one I don't think we've seen a lot. We have both Diane Garcia and Chris Paulson here in the room, and Jim Stevens too. But I don't know if Diane has ever seen this before. It's not a common way to get qualified. Usually it's not
I've
the
seen
primary
hives,
way at all.
I've seen beekeepers, but not this number, so.
And that was the primary.
Usually for beekeeping, it is the other use that qualifies them. So it's 5 acres of pumpkins, and they put bees there to pollinate the pumpkins. Well, the pumpkins is the main production. The bees is, secondary. Currently, we do not have any parcels of land that qualify with just bees, because there has to be something for the bees to utilize on the property. If they are just putting the bees on for 1 month in December, during the month of December, the bees aren't flying around. The bees are inside the hive.
Right.
So there is no production, there's no pollination.
Just like keeping horses and cattle inside when the weather's bad.
There's nothing happening. So for our county, and as I talked with the State Tax Commission, they talk to all the other counties all the time. And currently that is not the case. It is beekeeping, bees, apiaries are in addition to other production. And that's why in the standards of practice, it even says if your property is a hillside or it's grazing 3 or grazing 4, then there isn't anything sufficient for the bees to utilize. So if the bees fly a mile down the road to an orchard, that's great. They're pollinating, they're making honey, but they're not qualifying that property that they're on. There's no production occurring on that
Yeah,
property.
and-
And that's what they
Yeah, I got
clarify.
that. And his interpretation is it does the good for the entire area, not
Right,
just.
and that's the
yeah.
USDA, that's the federal government, and the state tax commission is the farmland assessment.
Right, but I mean, the USDA is saying this is a good thing.
Right,
of
and
course.
beekeeping is a good thing, and
Yeah.
bees pollinating are a good thing, and honey's a good thing, and all those are good things. But we have to look at each parcel, and so looking at a parcel, what production is occurring on that parcel, and that's where we come.
So once again, I hear you saying that you're looking for production. But when I read the code said, yes, production is one thing that would qualify an apiary. But then it also said other things that may qualify an apiary. It didn't say and, it said other things that may qualify an apiary, which basically means or wintering of bees, utilizing the property for the shipment of bees, and that's what's occurring on this property. And that's why I'm in favor of granting this appeal, because I understand the production side of it. But in the law, it specifically says other things that may qualify them, and it included wintering bees. I don't care if they winter them for 4 weeks or 6 weeks. It said wintering them. Wintering bees counted, and it counted the whole process of preparing them for shipment to orchards, right? That's where I feel that this qualifies, and that's where I feel that we've applied the incorrect area of the law. We're looking at for production, but it said other things that may qualify them beyond production.
Just for the
are
sake of clarification,
staging,
Commissioner,
shipping, and wintering.
just for the sake of clarification,
Right.
what the law requires is two things. It requires an active devotion to agricultural production, and it requires a reasonable expectation of profit. That's the Farmland Assessment Act. The standards of
And I see
practice
both.
say
And I
that
see both.
some
I
evidences
see a
of
reasonable
reasonable
expectation of
expectation of profit for a honeybee operation include, and they list a number of examples of evidence of the reasonable expectation of
Is
profit.
this a honeybee
from-
operation or is this a pollination operation? Once again, I think you're applying the incorrect area of the law. You're saying they don't make enough money off of honey. I'm saying honey, from what I understood, from when I stood there and talked to them last meeting, was that honey was only a part of it, that they get their money from shipping the bees out for pollination. Once again, I think there's two areas, and I think we're convoluting them, or at least when I say you are convoluting them. I don't think they're expecting their profit from honey production. I think they're expecting their profit from delivering their bees to farmers. And they happen to get honey. And I understand that you're looking at production per acre, but it also says other things that may qualify them. And it includes staging and shipping and wintering. It doesn't say they have to winter. By the way, wintering would actually mean that they expect that it's not year round because it's only winter. So I think you're right. There are areas of the law. I feel you're applying the wrong standard to this farm.
What I'm saying is that the Farmland Assessment Act requires both prongs. It requires active devotion to agricultural production, and it requires a reasonable expectation of profit. And what the standards of practice 7.5.1 articulate are some evidence of a reasonable expectation of profit for a honeybee operation include and list the different dozen or so ways you could help provide evidence of the reasonable expectation of profit. It's still just one of the two prongs that is required to qualify for
Right.
detailed assessment.
Right, but you just said a honeybee operation, not an apiary. They're not the same.
You got to have both
An
prongs. for either one.
apiary for
let's go ahead
pollination,
and discuss.
and
I'll call
you're
the
using the
president
terms
this time.
interchangeably. So how do I trust that you're not even applying the right part of the law if you're not even using the terms correctly?
I'll go ahead and call the question. So what we'll need to do is, I'm going to recommend we continue this because as Commissioner Lee mentioned last time that he needed additional insight, so do I. And I apologize for everyone who's
This
here for
is
this.
frustrating.
It is
because
very
he's paying
frustrating.
a lot of money. And I think we've.
Can you tell you what? I'm just going to make a motion to approve. If you choose not to second it, that's on you, Commissioner Sakovich, but I'm going to make a motion to approve this.
Okay, that fails for lack of second. So then then there's no action taken on this item today. It will have to be reheard at another date.
Are we going to come back 3 times and 4 times? You know, they even have said in their.
Yeah,
their
if Commissioner Lee
standards are
doesn't show up
vague.
next time, you'll probably have to come back too. Yeah.
But it's
Unfortunately,
in their
and I apologize for that.
communication, they say their standards are vague. It's not our fault. It's our job to make things not vague. It's our job, because then how can somebody read it and understand what they're required to do if the state tax commission doesn't know what it means?
Now, that's why I'm kind of torn by these two documents.
No, but you need to err on the side of the public. It's the state tax commission. They're the ones that adopted and revised these.
That's why we'll have to
procedures.
pick this up at another date. So this will have to be continued by default. Okay,
I'm not very happy.
Well, I'll make a motion to adjourn since we're not going to get anything done here. I'll make a motion to adjourn.
any other comments from council?
None at all.
Okay, then
I made a motion to adjourn. We need to vote on the motion that is non-debatable. I made a motion to adjourn. We don't need to hear from council.
okay, that's it.
All right, bye.
Thank you, Alice.
Goodbye.